Welcome everyone. My name is Vito. I work as a legal advisor for the biggest right to die society in the Netherlands, the NVVE. And in the Netherlands, you might know, we have the oldest law that still exists that regulates euthanasia. But when the law was drafted, there was also arguments against this law. And one of these arguments was the argument of the so-called slippery slope. Nowadays, in many other countries, a law is drafted, which is very good news. But also in these countries, this question reoccurred, the question of the slippery slope. And for that reason, it might be interesting to tell you whether this fear of the slippery slope has been materialized in the Netherlands. So first of all, what is the slippery slope? It's the idea that a relatively small first step will lead to several other events resulting in an outcome that is usually negative. So it's always about the first intended step and the second not intended step, but that will result from the first, say, the people who fear. When it comes to euthanasia, the reasoning is as follows. If we allow euthanasia in situations in which people are mentally competent and suffer from a terminal illness and are in constant pain, so this is the first step, then we will in time also allow euthanasia in other situations, like there is no terminal illness, cases of dementia, in which the people might not be competent anymore, psychiatric disorders, old age complaints, only being old and suffer from that, or completed life. Yeah, I have to say one thing about, if this happens, that would be a lack of democratic legitimacy. So for that reason, it's an important question to ask, has this fear been materialized? In my presentation, I will explore whether this slippery slope is there. And I will focus on two questions. First, has and is nowadays euthanasia applied to the 5 groups you see here? And then, if this is the case in practice, is this being foreseen by the legislator? Because that's also important. So let's turn to practice. I'll show you some numbers. We always like these. Here we see the numbers of euthanasia in general, so all the cases of euthanasia. And what we see is that the number is still growing, or it's growing and it's still growing. Yeah, then let's have a look at the other categories. Here we see an empty screen, and this screen stays empty. And that's because in the Netherlands we don't count the number of euthanasia in cases of there is no lack of terminal illness. However, we know that already from the start we don't have terminal illness as a requirement. So there have been a lot of cases in which people were not terminal ill or were not in the dying phase. But it's not counted, so I can't give you numbers. Dementia. I think you all know that there are 2 phases of dementia. The starting dementia, in which a person is still competent, and the advanced dementia. Because dementia, you know, it's a progressive brain disease. And at some point, you're not competent anymore. This statistics is about both situations, so the starting dementia and the advanced dementia. It must be said that euthanasia in case of advanced dementia is seldom applied. For instance, in 2017, we see that the total amount of euthanasia in case of dementia was 169. Only 3 of them were in advanced dementia. Then we have the psychiatric disorders. We see that the first case that euthanasia was applied in such a situation after the law was already in 2003, But we see that after 2010, the numbers are rising. And also this seems to grow still. Then we have the accumulation of old age complaints. I think I have to explain this term. It's about a situation in which a person suffers from several complaints, which are as such not very severe. Think of blindness, think of hearing problems, think of bone weaknesses, instability of the body. Altogether, they can form an accumulation of old age complaints. Which is important is that these complaints must be medically classified. So when you're old, you can also encounter other problems, like that your friends are dying, but that's not an old age complaint. It must be medical. And in practice, of course, they will lead to reduced quality of life. And you see in the statistic that only from 2013 on, these numbers are counted. From the period before, we don't have statistics, but we know that already in the first year, a case was shown in which a person with multiple old age complaints was given euthanasia. So most likely this practice did not start in 2013. Then completed life, we heard something about it before. Also in the Netherlands, there's debate about it for 2 years, at least. And completed life is the term old people use for the feeling that there's nothing left of value for them in their life. It's the realization that all their, it's difficult to say this, but all their life events, everything that matters to them is lying behind them. And they don't see a future anymore. Sometimes this feeling is combined with medical complaints, like for instance, the herefore called old age complaints. In that cases, a physician can help them. These numbers are on the previous slide. If only the feeling of a completed life is present, as you see here, no physician has ever helped someone. So, then, yes. Okay, what we have seen now is a growing practice of euthanasia. Only in case of the completed life, there is no practice, but all the other 4 groups, there is a practice and it's growing. The question is this practice a so-called slippery slope? Is it the unintended second step? Or was it already foreseen by the legislator? Was it only in the first step? Well, let's have a look at the law. First, the text of the law. And there we will see that in the requirements, the term suffering is very broadly defined. It speaks of unbearable and irreversible suffering. But what does suffering mean? Because everyone can suffer from anything. We can suffer from a severe disease. We can suffer from a not so severe disease. We can suffer from pain. We can suffer from knowing that we're going to be in pain. We can suffer from knowing that we're going to die. We can suffer from the knowledge that it takes a long time before we will die. We can suffer from having bad luck. We can suffer from having a lack of money. And we can suffer from a broken heart. And we can all call this suffer. So when this is, if you reason like this, then all these situations can be brought under the scope of the law. But of course, the scope of the law is not that comprehensive. To know what this means, we have to look at the meaning of the legislator. And there is a lot of history about our law. And there has been a huge debate about all these situations. So that gives us now the opportunity to have a look at what the legislator said about the 5 situations I discussed before. So the legislator said things about the lack of terminal illness. Must there be a dying phase? The legislator spoke about psychiatric disorders. The legislator also spoke about dementia. Sorry. The legislator did not explicitly speak about old age complaints, but the legislator spoke about completed life. So what does it say? Did it say? Already before the law in 1973, there was a case in which a lady helped her mom with dying, and it came to court. And in this situation, Madame Posma, the lady who died, she was terminally ill. And it was brought to the court as an argument that it was justified in this case. And the court judged that it could be justified. In that case, that was not the case because there were other problems, but that being in the dying phase, being terminal ill, was not necessary. And years later, the legislator adopted this view. You can see here. There must not have been a dying phase. It's not required. So this was already in the law from the beginning. If we have a look at the psychiatric disorders, some of you might have known about the famous Chabot case. It was also before the law. And in that case, the court said that the specific nature of an emergency situation resists against a general limitation, like, in this case, that the suffering must have a somatic cause. And also this view was adopted by the legislator. You can read that in an emergency situation, that is not simply excluded on the ground that the suffering of a patient does not have a somatic cause. So the outcome was also if you have a psychiatric disorder as the cause of your suffering, euthanasia can be justified. So from now on, we already have seen 2 categories in which the legislator had foreseen that this could happen. And let's have a look at dementia. Because also in the Netherlands nowadays, there are physicians who say that dementia was never foreseen by the legislator. And I mean euthanasia, in case of dementia, of course. Well, the legislator said a lot about it. At first, they said something about the first stage of dementia, in which a person is still competent. And it said that if you are having dementia and you're still competent, then you know what is coming, and you know what all will happen. And maybe you have seen a relative who has suffered from dementia. And only this knowing can result in unbearable suffering. And then what about the advanced dementia? Also about that, the legislator said something. As you know, we have the advanced directive, in which you state your will, for in case that you're not able anymore to express your will. And it was exactly for the situation of dementia, in which you're not able anymore to express your will, that this directive was meant. It is explicitly stated by the legislator. So I can't express this not enough times. Also, euthanasia in case of advanced dementia was foreseen by the legislator. As I said, the accumulation of old age complaints, like the blindness and all the other old age complaints you might suffer, they're not foreseen by law. I haven't spoken about this in the legislative history. However, in 2011, our Royal Dutch Medical Association brought a statement because there was a lot of not knowledge. There was a lot of people didn't know if it could be brought under the law or not. And then our medical association said, yes, it is an example of medical suffering. So it can be, you can do it as a physician. And this has always also been summarized by our review committees in 2015 and 2018 again. In 2018, it's also concretized because there are mentioned some examples. You see here visual disturbances, hearing disorders, osteoporosis, osteoarthritis, balance problems. So it shows that these complaints are also in practice experienced by the review committees. Then finally, completed life. I'm looking at Rob because he was there. In 2000, just at the moment that our law was coming to be realized, a case was brought to court. And in that case, the question was asked, if a person has not a medical disease, but only suffers from the feeling of a completed life, can that be reason to allow euthanasia? But when this case came to court, the politicians heard about it. So that brought a political discussion. And first the religious political parties, but also some other parties, they didn't feel for this. So it forced the legislator to do the following. It said that suffering that results from completed life will not be covered by this bill. It was the only way in which the bill could be realized. So completed life is not covered by the bill. And it's quite funny because, of course, the Brongersma case came to the Supreme Court, and in the Supreme Court case, the judges, they said exactly what the legislator said, because they looked at what the legislator had said. So it was a funny interaction, if the outcome was not so funny for our members. So what can we conclude? First of all, the scope of our law is very broad. That makes it maybe difficult to compare with other countries. But let's have a look. This is the summary. I'll have it with me. You can take it to home if you want to. And first conclusion. In situations in which there is no dying phase, or in which there is no terminal illness, in which psychiatric disorders play a role, and in situations of early dementia, there is a practice, and it was foreseen by the legislator. So I think we can say that this is no slippery slope. According to the law, there is space when it comes to euthanasia in case of advanced dementia, you've seen. However, in practice, this happens seldom. So this must be the opposite of the slippery slope. My third conclusion. The law says very explicitly that completed life is no reason to allow euthanasia. And in practice, this never happens. Our physicians are also a bit afraid for these situations, because our physicians, that might be useful, they're very afraid of the law. Maybe not very, but they are afraid of the law, and they know the law, or they want to follow the law. Let's say it like that. Then my fourth conclusion, the old age complaints, you can debate about that, because it's not explicitly foreseen by the legislator. But on the other hand, the legislators talked about medical issues. This is only an example of some medical issues. The problem is coming because sometimes this is used by people who suffer the most from the feeling of a completed life, together with these old age complaints. That makes that it might look like something which is not meant by the legislator. Yeah, this is what I said. If you think, well, you said you did some arguments, but they're not convincing yet, or I want to know more about it, I read an article about it. I wrote an article about it, because now I had only 15 minutes. I hope I was in the time. And the article will be on the website of the World Federation. And I have also 10 articles with me, so if you're willing to read it, then come to me. I was asking for questions, but there's no time for that, so thank you for your attention.